clauses. The question is that clauses 1 to 3 stand part. Chris Hipkins.
Thank you, Mr Chair, and happy to take a call on this, the closing section of the committee stage debate on the Education Amendment Act number 2, 2004. And it's a very sad day, I think, for the teaching profession in New Zealand and for democracy within the educational community in New Zealand. I don't think that the name of this bill actually adequately reflects just how bad this is going to be. This, of course, instills a low trust model within the teaching profession, a low trust model when it comes to university governance, and an anti-democratic model in all of those areas as well. And it has been strongly opposed by the teaching profession and by the universities and by all of the others who submitted to the Select Committee. Only, I think, about 14 of the hundreds of submissions the committee received were in favour of this legislation. I want to talk also in my comments on this section about the commencement of this legislation and express my deep concern and the concern, I think, of the opposition that this bill in effect uses what is commonly referred to as a Henry VIII clause, in the sense that it gives the government the ultimate discretion as to change the law at will. And that is something that this Parliament looks very, very unfavourably upon, and yet it is used in this legislation quite liberally. It gives the government the power by order in council to change the law. And that is something that we have for a long time been discouraging Parliament from doing. And in fact, the National Party, when they were in opposition, railed against the government having these types of provision in legislation. And in fact, now when they increasingly, in recent times, we have seen them using exactly those sorts of provisions in legislation, and they're not good. Constitutionally, this is a bad bill because it removes the power from the Parliament to create the laws of New Zealand and hands it to the executive. It means that the executive at will, the ministers of the Crown, or the Governor-General by order in council, which means on the advice of the ministers of the Crown, can change the law without reference back to the Parliament. That is something that is discouraged, should be discouraged, and of course it's named after Henry VIII because, of course, he would get Parliament to pass legislation that would give him the ultimate power, and it would allow him at will to change the law, and therefore he had no further need for the Parliament. That is something that we don't want to have, and therefore we jealously guard against these types of provisions. There is no good reason for this. It's not like the government didn't see this coming, and it's not like they haven't had plenty of time to prepare, because of course they introduced this legislation a very long time ago, and then despite their rush through the Select Committee, not giving the Select Committee any additional time to consider the legislation, even though there were so many submitters who wanted to be heard, they brought it back to the House well in advance of the last election with the intention of progressing it before the last election, and then their own utter incompetence meant that it didn't get progressed before the last election. They easily could have deferred the report back of this bill to give all of those submitters who did not get to be heard the opportunity to be heard on this legislation. And I think that's the real irony of the commencement of this coming in by order in council, or as late as September 2016. So that's nearly 2 years away before this legislation would fully be implemented. And I think that the real shame of that, given that they have now given themselves this power to defer the implementation of it, the real question for the government is, why didn't they therefore take an extra month or so and allow the literally hundreds of submitters who were turned away by the Select Committee the opportunity to have their say on this legislation? Because there were heaps and heaps and heaps of people who wanted to have a say on this who were not given the opportunity to do so. And I can say, Mr Chair, that I sat through days on end of the Select Committee hearings on this legislation, and I would, as much as it was tiring and exhausting, I would happily do so again, because that is the essence of democracy. And I think the Parliament does a great disservice, and the government does a great disservice to the people of New Zealand when it simply stops listening and says, no, we've heard enough, we're just going to go ahead and ram through legislation without further reference, particularly when it is controversial, particularly as in the case of this legislation, when the ultimate subjects of it pay for this themselves, have no say over the governance of this body themselves. So this, and I'm referring specifically to the Education Council of Aotearoa New Zealand, or in the case of the provisions relating to tertiary institutions, once again, they have been overwhelmingly opposed to it. So why rush the legislation through, Mr Chair?
Chris Hipkins.
Why rush the legislation through when in fact clearly there's no rush? Because if there was any great rush, this would be coming in by order in council straight away after, not by order in council, but straight away after it is passed by the Parliament and received the royal assent. Unfortunately, that's not going to be the case. So this is bad law. Finally, I guess just to wrap up this and summarise the concerns that have been raised, there have been many and varied, but if I could summarise them thus. The lack of democratic representation on university councils and on the Education Council of Aotearoa New Zealand is very concerning, it is very handed and it is anti-democratic. The requirements that it now places upon the teaching profession are also heavy-handed. It is a very low trust model that disempowers teachers and says to the teaching community they cannot be trusted, and therefore government needs to seize control of that profession in a way that they don't do with just about any other profession in the country, and they wouldn't do it to the medical profession, doctors or nurses or any of those others, wouldn't even do it to real estate agents, and so therefore why are they doing that to the teaching profession? No justification. It is a bill that transfers costs away from government and onto the teaching profession by massively extending the powers of this professional regulatory body to include things that currently are covered by the employer, by the Crown, and it transfers the cost of those onto the teaching profession themselves. I want to know from the government, are they going to give teachers a corresponding pay rise in order to meet those additional costs? Because you can bet your bottom dollar that within a few years teacher registration fees will be increasing significantly to pay for the costs of the additional compliance burdens introduced by this legislation. This is a bad bill. It has been strongly opposed by just about everybody that is subject to it. Those concerns have fallen on deaf ears when it comes to this government, and I certainly would encourage the current government to think again, to go back, look at the overwhelming number of submitters who were opposed to this, listen to their concerns and make the amendments necessary so that this regulatory body can actually have the support of the profession that it governs.
Mr Chair.
I call Catherine Delahunty.
I'll take a